Are you confused about credit agreements in South Africa? You're not alone. Many South Africans struggle with understanding their rights and obligations. Today, we're diving into the top 10 rights South African consumers have, under the National Credit Act 34 of 2005, the NCA. The Act aims to promote and advance the social and economic welfare of South Africans, through the promotion of the development of a credit market that is accessible to all South Africans, particularly those who have been historically unable to access credit under sustainable market conditions. It further aims to ensure consistent treatment of different credit products and different credit providers and is aimed at promoting responsibility in the credit market by encouraging responsible borrowing, avoidance of over-indebtedness and fulfillment of financial obligation by consumers. Amongst other aims, the Act also discourages the reckless granting of credit by credit providers and contractual default by consumers. Let's break down the Act into manageable parts. First, we define credit agreements. The NCA applies to small, intermediate and large credit agreements concluded between parties who are dealing at arm's length within South Africa. Small agreements are those with a principal debt of up to 15,000 rands. Intermediate agreements range from 15,000 to 250,000 rands. Large agreements include mortgage transactions exceeding 250,000 rands. Now, let's explore the top 10 sections of the NCA. 1. Section 61. Protection against discrimination in respect of credit. This section requires credit providers not to unfairly discriminate directly or indirectly against any natural person, juristic person or an association of persons on the grounds of race, gender, marital status, ethnic or social origin, sexual orientation, disability, religion and conscience amongst others, when doing any of the following acts. Assessing the ability of the person to meet the obligations of a proposed credit agreement. Deciding whether or not to refuse an application to enter into a credit agreement. Proposing or agreeing to terms and conditions of a credit agreement. Determining whether to continue, enforce, seek judgment in respect of, or terminate a credit agreement. The full set of criteria can be found in the NCA. And this principle applies equally to credit bureaus, credit ombud, debt counselors, employers or trade unions when acting in terms of the NCA. 2. Section 63. The right to receive information in an official language. This section gives consumers the right to receive any document that is required in terms of the NCA in an official language that you read or understand, to the extent that it is reasonable, considering usage of such language, practicality, regional circumstances, etc. Registered credit providers are required to make submissions to the National Credit Regulator for a proposal to make the required NCA documents available in at least 2 official languages, and to offer each consumer an opportunity to choose an official language in which to receive documents in terms of the NCA. Imagine you're applying for a loan. You should feel confident and informed about your options. The NCA works to ensure this by promoting fairness. It provides you with the necessary information and protections. Remember, understanding these sections can empower you as a consumer. It helps you recognize your rights and how to seek help if you face unfair treatment. In summary, the National Credit Act aims to create a fair credit market. It encourages responsible lending and borrowing. Sections 61 and 63 ensure you are treated equally and receive information in your language. More sections will be covered in part 2 of this video series. This video is intended for information and educational purposes only, and does not constitute legal advice. For any legal questions or challenges, please consult a qualified legal professional.